Acknowledge you in the. Right. We call to order a meeting, Nuisance Abatement Board at 1:37 p.m. And I guess this meeting is to.
Correct. For all of you who don't know, my name is John Heron. I am the town attorney. The purpose of this meeting is to have your first meeting organizational. So the first order of business would be to elect a chair and a vice chair.
John, I believe that council did that and it elected Monica. And in their ordinance, they.
That is correct. That's already been done. Thank you, Amy, for reminding me. So the next order of business would be, really, this is an informational meeting to, inform you now that you're members of the Nuisance Abatement Board. You have given up your life as you know it. Now have to operate under a certain set of rules that the Florida legislature has deemed apply to all local government agencies and boards, obviously like the town council and also the Nuisance Abatement Board. I certainly encourage all of you, if you haven't already, is look at the ordinance itself, and if you have any questions regarding what it says and procedures that are outlined there, you certainly can give me a call and try and answer them. I will tell you that my ability to answer those questions is somewhat limited, and I'll explain. The town council has designated, pursuant to the state statute that allows for nuisance abatement boards, at past organizational meetings and when there's actually a case to be presented to the nuisance abatement board, I am the designated presenter, and I will be advising staff. Under the state law and the code, the separate attorney will be advising you all on actually how to conduct the hearing and any questions that you may have in the context of what takes place actually at that hearing once it's scheduled. So since it's not adversarial at this point, you have the ability to sit here and answer any questions and inform you of what I'm going to about the Sunshine Law, Public Records Law, and voting conflicts and things of that nature. I'll start by just basically saying that you all are governed by all of those laws. Primarily, there's three: the Florida Public Records Law, Florida Sunshine Law, and the voting ethics and conflicts of interest statute that have been established by the Florida legislature. In order. First, public records law. Anything that you all do, that you receive or that you create in the course of being a nuisance abatement board is a public record. Repeat that. It is a public record. So, my suggestion or my advice to you is, before putting anything down on an email or on a text, because it does include text, think about what it is that you're saying, who you're saying it to, before you hit send button. For completely separate reasons, but work very well for me. By way of example, our law firm has a setup where when replying to emails in Outlook, it's normally reply all, or forward. Reply all button is way over here. Minimize the likelihood of an erroneous hitting reply all. And that's very important for you all because of the Sunshine Law, which we'll get to in a moment. So basically, all documents, papers, letters, maps, books, tapes, photographs, films, sound recordings, data processing software, or other material, regardless of the physical form, characteristics, or means of transmission, constitutes a public record under Florida law. I'm giving a shout out here to the Florida Attorney General's office because I'm using some of their source material. Because a lot of this is repeated presentation after presentation. So if it is in fact in the course of the business of the Nuisance Abatement Board, you not only as a public record, but as a member of the Nuisance Abatement Board, you have an affirmative obligation to maintain it. So it's not like you can send out the email or receive an email and hit the delete button. You must maintain it. So it is my advice to all of you, if you already haven't done this, if the clerk hasn't informed you, is I would, to the extent that you receive emails, or you will anticipate receiving emails regarding your function as a nuisance abatement board member, is create a folder within your, whether you use Outlook or Gmail or whatever, title it Nuisance Abatement Board. And any email that you receive or you send out, whether it's even from the clerk, take it over and drop it into that folder. And that way it's always there, it's always saved, and if someone were ever to make a public records request for any communications that any of you may have had regarding anything related to the Nuisance Abatement Board, you will be able to work closely with staff to respond to that public records request by making that data and information available to us. Please.
I don't know if this might be a question for you or for the clerk. To hundreds of emails a day, a lot of sensitive information, and I am wondering if we can get a town email address, because I don't want somebody coming in having to peruse confidential client information to sort through whether or not I've pulled all the nuisance abatement board.
Yeah, there are different ways to deal with that, and I understand and difficulty that face, particularly as attorneys, for those the two members that are in the profession, and I understand that. I don't believe, in the matter of course, that we make email addresses available to advisory board members. We have been asked that in the past, as I understand it, but have not done so, and continue to suggest or recommend that you create that separation system. As far as if a public record request were to come in, the first line is we're going to ask you to identify only that which is, we leave it to you. The situation where someone would come in and potentially audit your Outlook file or something like that is really on and showing that somehow, some way that someone makes an allegation that at that point, more than likely, a court would say, hey, there's a prima facie evidence that you somehow have this public record and you failed to disclose it. Because the assumption is if you give us access to that remotely or some other ways, that you're compliant. There are other ways, obviously, to search for general files if it ever came to that, to exclude that, only put in the keywords that are going to bring up essentially an email that you've inadvertently drop into the subfolder.
Okay. And I understand what you're saying. I think what I'm going to end up doing, though, is creating a separate email address for this material.
The other way, one way to help you make sure that you're compliant with that is whenever you send out, particularly on the outbound, so you can always copy the clerk. So that's automatically then going to be saved to our system, and we can check that. I know some places and some board members, every location is different. It's a matter of how you wish to do it. We're fairly liberal in how we do. I mean, I know that there's some municipalities that I've seen where they've said as a matter of policy that you are supposed to copy the clerk on anything and everything, inbound or outbound. So it's always preserved on our system. That is a way to make sure that there is that check and balance for yourself. Is that even with inbound, is once you receive it, is to potentially forward it to the clerk and saying, I received this, I want to make sure it's saved, so I'm forwarding it to you, and it'll be printed or saved onto the city system.
I already know how to set that up. I already know how to set that up in Gmail.
Yeah. So, but unfortunately, that is the case. And that applies, and there are some recent opinions as other alternative forms of electronic communication become popular, including texting. The courts have said those also constitute public records. So again, if you were to look on my phone, every text that I've received relating to anything is going to be found on my phone or backed up to a cloud. Again, be aware of that because texts do qualify as a public record under according to the Supreme Court of the state of Florida. That point that I mentioned before, you do have then an affirmative obligation to maintain those. If there's any question regarding whether or not something does or doesn't constitute a public record, particular email, you certainly can reach out to me and ask, and we'll get that answer to you. Those of you who really are looking for something to help you put you to sleep at night, there is online under the Attorney General's of the state of Florida's their webpage, a manual that's have a copy of the hard file.
I do not.
Little, they print it out if you're ever interested in keeping around. I wouldn't necessarily recommend. That's my job, but there is a lot of information that's available, and they have what's called the Florida Sunshine Manual, which is accessible electronically, and it goes through all the iterations and all the exemptions and all the different nuances of the public records law as well as the Sunshine Law, and how it applies. There are certain things that are exempt, but I would not anticipate in the course of your responsibilities as members of the Nuisance Abatement Board that those types of questions are unlikely to come about. Would there be something that's potentially subject to an exemption? Someone sends you an email that has someone's social security number. That clearly, the social security number is redactable. If a public records request were ever to come in for that particular email, before we turned it over to whoever made the public records request, we would redact the social security number because that's specifically exempt under the Florida public records law. As an example, there are some other ones, but as I said, I don't think that most would come into play for you all. If at any point you all have any questions, please feel free to interrupt me.
Will our communication come directly from you each time? Like, for example, on the safety committee, everything comes through Chelsea, so we reply back to Chelsea. Is everything mostly coming from our directive to the email, and then we reply back just to you, or do we see?
So it's probably going to go through the clerk for the most part.
Will be and everything come back to you. That's what I want to know.
Where I would, the kind of example I'm kind of talking about is, and I think it would, my perspective, suspect or inappropriate is if a property owner or an attorney representing a property owner were before you were to hear a particular case, sending you an email or a text saying, "Hey, this is BS," or conveying information to each of you that really is appropriate for presentation during the hearing. That's the type of communication that I would see that you might get. As I said, then it would be appropriate to provide that to the clerk, so she has a record of it. At some point, as the prosecutor, I'd like to see that as well, or I'd like to hear the property owner representative present. But as the trier of the case, those types of communications, just as if they were made to a judge directly, are actually inappropriate. And nuisance abatement hearings are considered quasi-judicial under Florida law. That means that we have to provide notice, provide the property owner an opportunity to be heard, to be represented by counsel, and that your decisions are based upon substantial evidence. And actually, a lot of that information is contained in the ordinance itself. So as a result, those types of communications are considered under Florida law what are called ex parte communications, and they're prohibited, or unless they're fully disclosed, and I have an opportunity to respond to them during the course of the public hearing. And I would argue, but certainly part of the function of your attorney, board attorney, once that person is on board, is to advise you that, creation of those types of communications, and deciding the case only on potentially an ex parte communication would be inappropriate. I certainly would argue that as the prosecutor, as if I were in a court of law. To some degree, that's, instead of one judge, it's all of you hearing the evidence and making a decision whether or not the town has proven that the allegations of violating the nuisance abatement ordinance have our burden of proof. Really, the gist of the public records law I've already covered. It really is just making sure that you preserve those records, if appropriate, make it available for copying by the town for disclosure, or providing them in response to public records requests from the outside, and then ultimately, as I mentioned before, just now, depending upon the nature of the communication, disclosing it as part of the ex parte communication disclosure at the beginning of each and every hearing that you all, of every case that you.
I think to piggyback off what Dawn was saying, and I don't know if this is what you meant, but am I correct to assume that the procedure, the procedure would be whatever cases would come in via you, and we would receive them from you, right?
Correct. So in the normal course of preparing for a meeting, we would prepare, the clerk would prepare an agenda, forward it to you all, listing the cases that are to be heard, and giving you a brief description of what the case is about. And then we would present the case before you on that given day, or cases as we don't have a lot of cases to present to you all, frankly. And we would be communicating, or you all would be communicating primarily with the clerk, and her giving you, or the clerk's office, providing that information to you all. Once again, the point of where there's actual cases to be presented, and I put on my hat as the prosecutor, actually, just as it would be inappropriate for the property owner or the property owner's attorney to have contact with you all, applies to me, and vice versa. So it's, that there are questions with regard to substantively the case before you. Those types of communications with me as the prosecutor would be inappropriate. You could ask your attorney or someone else, potentially in my office, a procedural question that we might be able to answer, or reserve that question for at the beginning of the meeting to ask the attorney who's appointed by the town as advisor to the nuisance. Sunshine law. Sunshine law is notice and an opportunity for people to speak, and that there be minutes of your meetings. Requirements of the sunshine law. As it relates to you all, it's one of you get together, more than one, and speak about matters that come before you. I want to make it clear, because there's a lot of people like, well, wait a minute. Met her. Speak to him? Of course you can. Okay? The Sunshine Law doesn't say you stop being friends or acquaintances or know each other, saying hi to each other. What it does say is that the only place that you can talk about a matter that involves the Nuisance Abatement Board or a case before you is when we're all together. Also extends back to the public records, communicating by text or by email. If you have a question, the proper person to address that question is either to the clerk or your attorney once you start getting into substantive of cases. You should not be communicating with each other, not be using intermediaries or third parties to communicate with each other. That's, again, prohibited by the Sunshine Law. It's common sense, I like to say. Also keep in mind, actually sometimes perception is reality sometimes in the things that you do. I remember in kind of a short story, to give you an example, the municipality where I worked, two of the elected officials have been friends for years. And sometimes after a council meeting, they would go out to dinner and have drinks. And then sometimes I'd go with them to have dinner. And one night, while they were having dinner and I was there, a local reporter walked in and, bug-eyed. Came up to me, she goes, "They're violating the Sunshine." No, they're not. So, number one, you think that I would allow them to do so in front of me? I have a legal obligation to inform them that they're doing something wrong if, in fact, they're doing something wrong. They're friends. There's nothing in the Sunshine Law that says that they can't be friends outside of the commission chambers, the council chambers. Fortunately, next morning, page, council member violating the Sunshine. Little qualifier at the bottom, well, they might be. But, more the issue of the Sunshine. And I specifically had to call the reporter, and page 10 of the next paper, there's a small clarification and retraction. But no one's reading that. They were reading the big headline. So be aware of that. Again, use common sense, not suggesting at all that you stop being friends or acquaintances with each other, not stopping to say hi to each other, not going out to coffee with each other, but there will be those who will see that and go, aren't they Nuisance Abatement Board members? Right? And doesn't matter what we say or we do or how I've advised you here today. There's going to be those who feel that you. Obviously, in the context of meeting the requirements of the Sunshine, from the technical standpoint, the clerk is responsible for providing notice, just as I did to you all for this meeting. Formal agenda will be provided, as I said before, and obviously minutes will also be kept. Generally speaking, unless there's a court reporter, they're not verbatim minutes, they're just action minutes reflecting general topics and what ultimately the vote on a particular issue would be, or is, as the case may be. And that's all that is required under the Sunshine Law.
Question?
Yes, ma'am.
Will we be just meeting on an as-need basis, or do you intend a regular meeting?
On an as-needed basis, there may be a need occasionally for an organizational meeting if one or more of you tender your resignation, boards that have a replacement, and if that affects who the chair or the vice chair may be, then frankly, there's been a lot of discussion about this nuisance abatement board. I thank you for your participation and your willingness to attend, but in a perfect world, from my standpoint, all hopefully won't have to meet that often. And there are a lot of moving parts to that process. I don't want to go into much detail. It's there, but there's a specific process. We are approached by law enforcement. Proper documentation is made. The determination is made that there's a need, and all the criteria for bringing the case forward has been met. And then we would schedule through the clerk a meeting that's mutually agreeable to all of you all, and with those particular cases or case that you're scheduled to hear on that particular day. By way of example, when initially was designated as the town attorney, kind of counterpart to the code enforcement special magistrate, we were having hearings every month through good work of staff. We're now down to having to schedule meetings of the special magistrate every other month. Because we're getting better compliance up front. There's not as many cases that need to be presented to the special magistrate. So I would envision the same thing with you all. I think that the actual creation of the designation of you all as a nuisance abatement board maybe has helped address some of the concerns that some in the community may have had. And again, so not I don't want to say how willing how ready you're to hear your first case, but I can't tell you when or when that might be.
I have a question real quick. How are cases submitted? I know, and how do they get reviewed and how that process starts? I know you said it's through the Sheriff Department brings you information. However, I mean, if they're making the dictation that, okay, let's just say there's a house on the south end that deals drugs. They've been there 3 or 4 times. I'm never going to know about that. I live on the north end, so I wouldn't hear about these things. How does it get back to us or to the community? So one, it mitigates any neighbor fighting with neighbor, things that really aren't part of this. This is supposed to be the serious things that are going on. Well, how does that work?
The code and the ordinance that you operate under does provide and does allow for neighbors, for members of the community to file a complaint to try and initiate a hearing or a case before you all. But ultimately, in order to be able to present the case to you, there has to be a determination, much like there would be in it's not apples to apples comparison, but the state attorney making a determination of a crime has been committed. All the elements of the crime can be established, and they file charges against someone for taking them before a criminal court judge. Here, there would be a determination. We'd look at the complaint filed by the neighbor, any information brought to us by the sheriff, and an independent analysis and determination whether or not all the essential requirements of the ordinance have been, all those boxes have been checked off to bring the case before you. Whether or not you potentially hear about it in the community beforehand. Hopefully there's not a lot of that type of, because again, back to one of my previous comments, you sit as the judge and the decision maker, and therefore, if the people are reaching out to you to say to you, hey, terrible things going on in our community, I know you're on the Nuisance Abatement Board, that would be considered to be an ex parte communication. In a perfect world, your response would be, hey, I appreciate your concerns, but what you really need to do is to either report those facts to the sheriff or come to the hearing and testify, which you will have the right to do so, but I really can't discuss it any further.
Who's we, when you say we make a determination of whether...
Collectively, the nuisance,
I'm sorry. Before it comes to the board, you said we look at to see if all the elements have been satisfied. Who's we? Just you?
town staff and myself, but ultimately I would have the responsibility for making the determination that as a person who's going to present the case, that I have a good case to present to you all, and I'm likely to prevail. I don't want to pick up a lot of people's precious time in bringing cases forward that the elements aren't there.
On staff. So, I mean, I just kind of want to have an idea of how, so something comes in and it gets reviewed by you and,
Potentially the manager, certainly the district commander, sheriff's office would also be part of that conversation and analysis. I might reach out to the actual deputies to get additional information that may not be in their reports. I want to say that there may not be someone else. For example, be consulting with the planning department to make sure that the zoning, what is it isn't allowed in that zoning category. We're still talking primarily about criminal conduct serving the basis of moving forward with administrative proceedings. So that I don't really anticipate anyone else than when I say we.
okay, and who ultimately makes I mean, this is obviously a discretionary call whether, to bring the case, right? And to use your analogy, who ultimately makes the decision to file the charges? To use your analogy.
Yes.
Yeah.
No, it's best analogy out there. So thank you. Me. And I'd probably again would consult with the manager as well, and I'd make sure that the commander is comfortable making his deputies available to be here to present the case because they would be material witnesses for me to be able to prove the facts that I believe I'd have to in order to be able to convince you all that there's been a violation of the new regulations.
Are we going to publish on our town website the difference between the types of things that this committee will be looking at as opposed to code enforcement? So that, or does somebody dictate that and separate it out? Because that was one of the, I'll be honest, that's one of the complaints or concerns with people, that it's going to be neighbor turning on neighbor on things that really does not have their seawalls too high or whatever it is. Are we going to lay it out so it's very clear to everyone? So this isn't a witch hunting, which it's obviously been termed that?
Part answer. The ordinance is very specific of what are the categories of items that the town can bring before the new abatement board. They were. I know that I mentioned them repeatedly during the public hearing process for the adoption of the ordinance, but certainly they're there. We can already doesn't exist to the extent that we have a link for the nuisance abatement board, like we have for the LPA and the advisories. I'll work with the clerk to see if we can also put in a link to the actual regulation, because the regulation spells out very specifically what your authorities are and the only types of cases that can be brought before you by me on behalf of the town. Change, but graffiti and related to gang activity, prostitution, drug activity, if not three, if you want, I can.
Sorry, I just want to make sure that we get it out there.
Yeah.
That'd probably be something good for us to have in our hands, too, a copy.
Have you not been provided a copy of the ordinance?
I have, but I do want to call your attention to the fact that the ordinance refers to specific Florida statute. It opens the door wide what can come in as a nuisance?
No, the Florida, the references Florida statute are very specific, as to, and they mirror what's in the ordinance. You can't go outside. The ability to have a nuisance abatement board is established by state law. And those restrictions on what cases can go to a nuisance abatement board, that we have in our code are straight out of the state statute.
They are, but there's more in that statute, and the statute's referred to generic.
Then we're limited to what we've adopted.
Actually, there's something in there that says the community. That's in that statute as part of the definition.
I will look at that and I don't believe that,
I
my
know
recollection
it's
is that we
not
didn't do
gonna
that.
be- I know it's not going to be that easy to get rid of traffic, but
But yes, to your point, we are very limited, and I can tell you that myself as the town attorney, and the council asking me questions about it, we're very specific about what the limitations are, and the 5 or 6 categories or types of cases that we're able to bring before the nuisance abatement board. Everything else, arguably may be subject to code enforcement and the special magistrate. Will there be potentially neighbor versus neighbor complaints, whether it's code enforcement or nuisance abatement board? Nothing would surprise me.
Okay, so just correct me if I'm wrong, but I would say that a case that is borderline, we would probably decide that as a threshold matter. I mean, that would be, akin to whether or not we've got jurisdiction. If we feel that we don't have the authority to hear that case, that would be a threshold matter before we'd proceed with it substantively.
You're absolutely correct, and if a property owner or their counsel raised that as an issue, that would be a threshold issue for the board to determine whether or not the facts as presented on a preliminary basis fit within the 4 corners of the ordinance. You're able to hear or not hear, and the gatekeeper moving forward. I'm not going to bring forward a case that I don't have a comfort level that it falls within your jurisdiction. Certainly, that is your point is appropriate and right on point. Voting conflicts. As members actually your decision-making body, your powers are greater than, what is the other advisory board that you sit on?
Safety.
Safety. Okay, so the safety committee is advisory in nature. They can only make recommendations. You all are the decision makers. And so, that makes a difference and to some degree, particularly in the application of the conflict statutes, because as the ultimate decision maker, you need to make sure that you're not running afoul of those prohibitions. Pretty simple, which is if you're a family member, it's a little extended. I think it includes brother-in-laws, sister-in-laws, mother-in-laws, father-in-laws. If any of those type of category of individuals, obviously siblings, are the subject of the proceedings, then you have a voting conflict, and it would be for you all to, whichever case-by-case basis, to disclose that conflict and refrain from participating in the proceedings. There is a form that the clerk has that she will give to you for you to sign. It has to be filed with courts?
I just
Oh,
file
no,
it with the minutes.
The voting conflict, who do we?
Just file it with our minutes.
Okay. So there's a record that you've disclosed the conflict and that you are properly recusing yourself from taking any action on it. Conversely, there's a state statute that says, as advisory bodies and as well as decision-making bodies that you are, that unless you have a conflict of interest, you're duty-bound to vote. So you're, either you have a conflict that would prohibit you from voting, or you have to participate and vote on the matter. Abundance of caution. Or you believe that there may be a conflict, reach out to us as far out in advance as possible. Either someone from my office or the attorney, that's the board attorney, will communicate with the Florida Commission on Ethics to determine whether or not you fall within one of the prohibited classes. If there's a voting conflict issue, to get guidance on whether or not you should or you shouldn't.
Does a Zoom presence count as attendance in a vote?
Yes. Even in what I'm now calling the new normal, yes, to a point. The ability for governments to meet through Zoom and vote was to some degree a function of COVID-19. There are a series of Attorney General opinions that do allow for remote participation of one or more board members, but in order to be able to actually meet, thus to have a quorum, there must be physical presence of those necessary to the minimum amount to be able to meet. Rule now, now that we're in the new normal and we're returning to what used to be normal before COVID-19, is that if you are going to participate by Zoom, generally that's only allowed in circumstances where there's an illness that prohibits you from attending in person, or you, for example, have a pre-planned trip, family vacation, and the meeting got scheduled after those plans have already been made, and there's you request for you to appear through Zoom from wherever you are. And those are basically two circumstances in which attendance at a board meeting would still be allowed remotely. Otherwise, it's here. I do know of some jurisdictions, Fort Myers Beach, that have created rules where they're like, okay, well, as long as you're physically all in one building, you can appear remotely, and that's kind of a workaround. But for some time here in Fort Myers Beach, all of the town council as well as the advisory committees have all been meeting, but not that you can't.
Speaking of quorum, there's an empty seat, right? There's still an empty seat. Is there any plan to?
Mayor hasn't appointed anybody yet.
It already done. Okay. Yeah, we'll get.
Mr. Aaron, if I may?
Yes, sir.
Are there any hard and fast rules on representation by an attorney, conflicts of interest on current representation or past representation?
Same rules would apply, or in general, yes, there would be, but I think that you can, in such instances, as attorneys, I would double up. I'd check with the Florida Bar.
Well, yeah.
And then with the Ethics Commission. If the Florida Bar, for whatever reason, says that it's a conflict of interest, I would stop there. Don't go any further. No need to go. If not, if they say yes, then in abundance of caution, if you want, you could also check with the Commission on Ethics. I personally have found the Commission on Ethics to be very accessible, very informational, and very willing to talk to you. There are on a number of occasions for different people, practicing here in Florida over the last 30 years, where I've had infinite number of calls and given them hypotheticals where, hey, if this were to happen, and they're very good about giving you guidance right there on the phone. Sometimes, depending upon the potential nature of the issue, they will say, hey, well, we'll send you an informal written opinion, and then most extreme case, which are very rare, at least in my experience, where you actually have to request a formal written opinion from the commission. If any of those type of situations come up, obviously beyond where they are giving you an informal over the phone, then my advice would be don't participate in that particular proceeding until you've received a response from the Ethics Commission. Because once you participate, you can't unring the bell.
Participate, yeah.
Copy of the ordinance has been provided to you. I would on the third page, double-sided, public nuisance, 1, 2, 3, 4, 5, 6, 7, 8, 9 are the types of cases you can hear, and only those that are listed there. Unlawful sale, delivery, controlled substances defined by law. Gang for purpose of conducting pattern of youth and street gang activity as defined by law. That's public damage, PD. Prostitution or solicitation, illegal gambling, murder, attempted felony murder, aggravated battery with a deadly weapon, aggravated assault with a deadly weapon, and something declared to be a nuisance under state law. I think that's your. I will tell you that number 9 is the one that I have very rarely ever seen, and 5, 6, 7, and 8 are actually fairly new additions to the statute. It used to be 1, 2, 3, and 9. I'm sorry, 1, 2, 3, 4, and 9, and then the others have been kind of put in really recently. And the way that I understand, I personally haven't haven't had a situation where I've had to present a murder case before Nuisance Abatement Board. But my educated guess is that the attempted felony murder or murder are really going to come into play in conjunction with one of the other activities. Murders taking place as part of a drug sale, that type of scenario where you're bootstrapping the murder charge into the presentation before you all. General observation: if someone's facing a potential murder charge, Nuisance Abatement Board is probably not the first case, but if the situation should present itself, and we believe that staff, we believe that there's enough evidence and information in order to move forward with such a case before you. The question I think that was before, any person who resides in or is employed within the town may file a complaint with the Lee County Sheriff's Office about them. So, could it be your neighbor? Questions? One thing that you can do today, I think that's certainly within 40 is organizational provision here. Any you all have the authority under the statute and the ordinance to basically adopt, rules of procedure. Normally, most jurisdictions would say, an abbreviated version of Robert's Rules of Order. Frankly, up to you all. Personally, over the years, have found that Robert's Rules of Order in its full form is unwieldy, designed for boards of your size. They're rather more larger parliamentarian situations. On council has adopted an abbreviated set of rules. We can provide those to you as potentially as an example of what you might want to follow or not. Kind of as long as I would tell you that as long as you provide notice, an opportunity to be heard, and base your decision on competent substantial evidence, you're in compliance with the law. How you then conduct yourselves, you at the end of the day, as with any board, particularly with respect to aspects of the duties of the Nuisance Abatement Board, the chair has will ultimately rule on questions of evidence. There is a statement in here that says that the formal rules of evidence not required to be followed, but they serve as a guide. Kind of applies for procedure. Well, you would look to Robert's Rules of Order, but have to be that formalistic. As long as there's a motion, second, and there's discussion before action being taken, that's sufficient. People conduct themselves hopefully in an appropriate professional manner on this side, where we ask for the board to recognize us before we speak and answer your questions properly. Getting into the nuances of Robert's Rules of Order, don't necessarily need to, at least in my, it's ultimately up to you all. We didn't have anyone else show up, did we? Oh, yes.
Hey, Jennifer from Murph.
Okay. We're asked to make it available to all of our advisory committee. Doubling up. So if there's any questions, here to answer them. Other than that, I think that we've covered the basics of what the rules that you need to. We're here to answer any questions you may have now or a week from now or an hour from now. I will give each of you my card, available 24/7. The dismay of my wife and children. And please do not hesitate to reach out to me if you have. Let me check just before.
Required to file a financial disclosure.
Yeah, I'm sorry. Thank you. I was going to that. Your capacity as an advisory board member, I don't believe either of you file financial disclosure. Do you? Because this is a state-created board as decision making, I believe that, and I'll confirm this through the clerk to you all, but I'm 99.9% sure that each one of you is going to have to file on a yearly basis, for as long as you're a member of the Nuisance Abatement Board, a financial disclosure form, because you do have decision-making power.
I already do, due to being on the library board.
Okay.
So I guess that's one and the same.
Yes.
Yeah.
So if the only library board being separate from our other decision-making body is the local planning agency, and they also have to allow that. Once you get on the list, the clerk of the court will send you the form on an annual basis. There is a requirement that you pilot, now that you've your first meeting, first organizational meeting, it's within 60 days that you have to file the form. Then you'll get it on a yearly basis. They'll once you fill out the form, you can forward it to Amy, who will forward it to the actually supervisor elections.
You file it right with them.
Yeah. And it gets, and they'll send you, do you get one? Do they automatically generate to you? Yeah, yeah. So
We're
then-
always reminded of the deadline. I
Yes.
think it's July, maybe?
I think it might be July.
Yeah.
I'll call them and let you know what's going on.
At a point that you decide not to be a member of this board any longer, you also have a responsibility to file a Form 1A, which says that you are no longer a member of the board, so they don't have to keep track of you. I have to do it every time that I serve in this function, so I don't know why. That's a state law requirement, so keep that in mind. If the day comes, or when it does come, that you're saying, I don't want to do this any longer, you have that, again, that time frame to file your updated financial form saying, I don't remember. I don't, there are some going back to the voting conflicts, there are some nuances there that I don't anticipate necessarily being an issue for you all, because the scope of your responsibilities are fairly narrow. Let me give you an example that I can think of. It's really the only one that I can think of. If for whatever reason this board decided that, let's say, in lieu of the minutes I mentioned before, you're going to have a court reporter transcribe, verbatim all your meetings. Putting aside that there would actually have to be council approval for that expenditure, and if you were to, if one of your close relatives that fall within the definition or the group of people I mentioned before was a court reporter, and you couldn't vote on the hiring of the court reporter because they may be applying or looking to one of the people who those verbatim transcripts. So that's a type of conflict of interest on the voting, the pecuniary aspect of the law. I just don't see necessarily happening with you all, but it's theoretical. So I just wanted to mention it because there is two components to that statute. One, the conflict of voting, if it's going to affect someone that's within the class of individuals, as well as if you're going to receive a pecuniary return for voting one way or the other. And I appreciate your patience and listening to me ramble on here about some of these more two aspects of local government, having said that myself, and wish you the best. And look forward to working with you all, even though when it's going to be more adversarial. Probably not with you all, with the others, with whoever may be the person or entity appearing. If you don't have any other questions, then it's appropriate to entertain a motion to adjourn.
Can I second that?